Hello there. This is An Architect Goes to Law School. Today, in a final contracts class session, we'll discuss remedies for breach of a contract. Remedies for breach of a contract are available to aggrieved parties when they don't receive the benefit of the bargain for which they contracted. More accurately, dispute resolution processes are available. Remedies are what are desired, with monetary damages being a subset of remedies to disputes. Breach of contract claims, in the context of construction disputes, may provide remedies as dictated by contracts, statutes, and the common law. Two major categories of relief for breach of contract are specific performance and substitutional relief. Essentially, specific performance is an equitable remedy when the property, goods, or services contracted for are unique or cannot easily be replaced with other similar goods, property, or services. Due to the unique qualities of individual parcels of land, specific performance as a remedy is sometimes sought in breach of contract cases concerning real estate transactions. While one might think that architectural services are unique, case law is scarce concerning specific performance that requires an architecture firm to undertake and/or complete design work. Finished architectural plans are a different situation, however. One case, Sokolov versus Harriman Estates, was about specific performance for construction documents that had already been completed by an architect but were withheld from the project owner by the developer. Here, the developer, quote, informed plaintiffs that the architectural plans could not be used to construct the house unless it was hired as a builder, end quote. The court held that, quote, specific performance is an appropriate remedy for a breach of contract concerning goods that are unique in kind, quality, or personal association, where suitable substitutes are unobtainable or unreasonably difficult or inconvenient to procure, end quote. In contrast with specific performance is the concept of substitutional relief. When one party breaches a contract, a prevailing party will seek to be made whole by available remedies. The most common way to be made whole through substitutional relief is to receive expectation damages. This puts the aggrieved party in the situation they would be in had the contract been fulfilled properly. For parties who have not fulfilled their financial obligations to another party, this means paying the full amount of the contract. For parties who have not completed the actions the contract required of them, this may mean paying an award of damages equal to the value of the incomplete actions. For example, if a contractor does not perform a portion of the work under the contract, they may be forced by a court to pay the value of the incomplete work to the owner. This would make the owner whole, giving them the benefit of the bargain. One court case, Lewisburg Building and Development Company versus Albright, held that, quote, expectation damages for breach of contract are generally determined by taking the difference in value between the performance contracted for and the defective performance that was given. In a construction contract where the breaching contractor leaves a project incomplete and the owner pays to have the project completed by someone else, awarding the owner the cost of completing construction is one way to protect the owner's expectation interest, end quote. Feel free to comment, ask questions, and suggest topics you'd like me to discuss. Next up, we'll switch classes and start talking about civil procedure. Thank you for watching An Architect Goes to Law School.